Good afternoon. This is Claudia Lewis and Ashley Saba from Venable. We are here to have a webinar to review CBD, a year in review. And before Ashley and I get started, we have a few housekeeping things. One, this webinar is giving CLE credit, and we will be giving the code to the CLE later on during this presentation. And again, I'm Claudia Lewis. I'm co-chair of the Venable's FDA group, and I'm with one of our senior associates, Ashley Saba. And while we have been dealing with lots of COVID-19 issues, and some of them related to CBD, we thought this would be a welcome break and reprieve to talk about something different and something that is on everyone's mind in terms of when we get past this, what will be the state of CBD. And I think before we talk about the state of CBD, we can talk about where we've been and what we think where we might be going. So we have a good agenda here. And I have to say that I think that my mom would be surprised that we're talking about CBD and these types of products. But we'll be talking about the plant background. We'll be talking about the Farm Bill, which I think was a relief to all of us. We'll be talking about CBD in foods, dietary supplements, and cosmetics. We'll be talking about enforcement in this area. Prop 65, there's some new information that THC is on the Prop 65 list, and how does that impact CBD products. We'll be talking about COVID-19 and CBD, and we'll be giving some industry takeaways. And although we have a packed agenda, we will have time for questions, and we'll be happy to take them as you type them in. So let's just start with some background. I think that, CBD hit the scene, and before the Farm Bill, there was certainly a confluence between CBD and marijuana and the understanding of the two. And so we all understand cannabis and that it's a plant species that's part of the cannabis genus species, and that the varieties can contain both hemp and marijuana. Marijuana, the distinction there is that it contains THC and is still treated and regulated as a controlled substances, Schedule I, under federal law. Whereas hemp, with the Farm Bill, is a cannabis plant, but is not typically used as a drug. It typically contains no THC or no traceable amounts of THC, and it is generally grown for use in foods, dietary supplements, fabrics, and textiles, and other types of products. So those are the two distinctions there, one being a drug and one not being considered a drug. So one of the things is that CBD is non-mind altering, so it doesn't have the same effect as marijuana in terms of, using the term getting you high, and it typically contains almost no or very little of THC in it. And so there are more than 100 terpenes in cannabis plants, and it's usually responsible for the aroma and taste, and there is a synergy of cannabinoids and terpenes. And so understanding the plant, we get to who regulates CBD. We have lots of authority here, FDA, FTC, DEA, and USDA. So the FDA is primarily concerned about labeling, how the product is manufactured, the intended use of the product. They're looking at product safety. FTC is looking at what types of claims are being made about them, whether it be express or implied claims. They're also looking at endorsement and testimonials. And they're looking at what type of substantiation you have for the product. DEA is looking at whether it's a controlled substance, which CBD is not. And the USDA is the one that gave us the Farm Bill, which exempted CBD from the definition of marijuana, and it is looking at the growth, cultivation, and the licensure of hemp. And each of these different agencies have different enforcement tools depending on what's happening with the product. FDA has inspections, can come in and look to see whether the product is being labeled appropriately, manufactured appropriately. They also, if they find some missteps, can issue warning letters. They also can do import detentions. They also have the authority to do injunctions. FTC is looking at whether you have substantiation, can send out inquiries in the form of civil investigative demands. And they also, in worst case scenarios, can do asset freezes or restraining orders or injunctions, and also participate in civil litigation. With DEA, we can look at criminal and civil penalties. And USDA, it really just depends on what's happening at the state level, how USDA might regulate what's happening with CBD. So here's just a map just talking about who regulates CBD. As we mentioned, we have various state-level agencies. We are also State Attorney General. There's State Department of Agriculture that would weigh in. There's State Departments of Health. We've had some issues with state boards of pharmacy in terms of whether it's compounded CBD. And there's definitely state-to-state differences on regulations in terms of licensing procedures and testing requirements. And Ashley will be able to give us some more information on that. And what makes CBD important? I feel like this slide is very important. We all know that consumers are very interested in CBD. They're prolific. There's very few stores, even shopping malls, where there aren't CBD products and CBD-related therapies. And so it's a very lucrative industry, ranging from cosmetics to edibles. Topicals are very popular. But the issue is that there's continuing legal uncertainties about using CBD, safety questions, scientific questions, and the like. And Ashley, I'm going to let you take it from there.
Sure. Thanks, Claudia. And hi, everyone. Thank you for joining us this afternoon. To Claudia's point, we had this environment predating the 2018 Farm Bill, which, sounds like a long time ago, but in reality was only, a year and some change, a few months, and a lot has changed in the regulatory landscape. Combined with that, as we discussed, we're learning a lot more about the plant itself, so how the terpenes and the cannabinoids interact, and, various agencies are also interested in that information, and we're seeing that from some of the questions that have been posed by FDA and other state agencies. So what did it look like before this Farm Bill was passed? So what we really understood was that, there was a cannabis plant, and very specific parts of the cannabis plant, after litigation, were carved out of the definition of marijuana. And I think we all sort of struggled with visualizing, what that meant and what that product actually would create. So taking us to the passage of the 2018 Farm Bill, it was actually signed into law in December, an early, Christmas gift to some of us who've been, watching this very closely. Most importantly, it, for the first time, created a federal definition of hemp, and it exempted that definition of hemp from the Controlled Substances Act. And I think, now we're all familiar with this threshold level of THC, which is 0.3%, and that really is, the linchpin of this definition. That is what FDA cares about, USDA cares about, DEA cares about, the states care about, is maintaining that threshold THC level. So in addition to, sort of broadening the federal definition, opening up the opportunity to, potentially transport, The Farm Bill also created a program to cultivate and produce hemp at the state level and then also at the USDA level. And we're starting to see those regulations at the state level roll out recently. It took a while for the USDA to sort of create their interim rules around production, but now we've also seen those. So that, you know, looking at the production and the cultivation piece made a lot of progress, both at the federal and state level, but as we'll be discussing later, that doesn't really solve some of these, you know, more difficult questions around advertising and the FDA piece of marketing. So one example, I'm just, you know, presenting Illinois, for example. This is an example of their new hemp production regulations. And you can see that there are licenses involved. You have to provide certain reports to the state, and you can only, you know, cultivate seeds from certain sources. And then there are also penalties associated with violating those very specific cultivation requirements. So what are the key takeaways? The Farm Bill, as I said, removed hemp as a controlled substance, yay, established a pathway for USDA and state-regulated hemp production. The key there is not hemp marketing or distribution, but just the hemp production element. And also repealed, you know, what were pre-existing industrial hemp research programs. What it did not do is legalize marijuana or marijuana-derived CBD, and that's a really important point. You know, when we're talking about this THC level, the USDA and DEA expect that the plant itself to be considered lawfully hemp, you know, has to maintain that 0.3% level. So, you know, what that means in a practical, for practical purposes is, you know, we would expect record keeping and a very tight controls on the entire supply chain to make sure that that THC level is under control and documented. So what it did not do also is change FDA's authority over cannabis. So that is something, you know, that we've been grappling with and FDA has been grappling with. On one hand, you know, seem to liberate the sale of products, but then ultimately FDA, you know, has its own statutory authority and they are dealing with questions they have around the legality of it and then also the safety. So speaking of FDA, we're going to switch gears to food that's regulated by FDA and CBD that's found as an ingredient in food. And I think right here I'm going to pause and just give everyone that CLE code, which is Venable CBD. So write it down, Venable CBD, if you're looking for a CLE for this. So we're starting to see CBD in various types of food. And the issue is, well, the issue is twofold. One, there's a statutory prohibition on including an ingredient that's been studied in or as a drug. Cannot be approved to be used as a food ingredient. And this is because all food ingredients also have to be generally recognized as safe. And FDA's so far, and this could change, taken the position that, you know, it, on one hand has not been provided with information to establish that CBD is generally recognized as safe. And then separately, they're sort of handcuffed by this statutory provision that prevents the marketing of an ingredient that's once been studied and approved as a drug. So similarly, dietary supplements. Now, we think of dietary supplements as having somewhat, looser regulatory controls, and they do, but they are still subject to FDA authority. So again, FDA has taken the position that this statutory provision that prevents a product that's once been studied as or approved in a drug is prohibited from being considered a dietary ingredient unless there's information that the ingredient had been previously marketed in or as food. And, I know as an industry, we've been sitting back saying, well, of course, CBD has been in food and it has been in hemp has a very long history, both in the United States and elsewhere. But so far, FDA, at least right now, is taking the position that it has not seen compelling evidence that that's the case, at least enough to overturn or circumvent, I guess, this statutory prohibition. So cosmetics are also regulated by FDA, and on the spectrum of commodities regulated by FDA, we would say, they are even more loosely regulated than, some of the dietary supplements that we talk about. So unlike food and dietary supplements, FDA doesn't have the same statutory prohibition against ingredients that have previously been studied as a drug. So you're not dealing with the reality of FDA having approved a CBD-based drug when it comes to cosmetics. Now, they do have an overarching safety hook overarching safety authority over ingredients in cosmetics, and interestingly are working with the University of Mississippi to understand a little bit more about the dermal application of CBD products. I view that as a positive. I think we're going to learn a lot of information based on that study, and it shows that FDA is, I think, moving in the direction of supporting its comfort level with the product being marketed in cosmetics, and otherwise has not taken a strong position against cosmetics, unlike it has for food and dietary supplements. I just want to be very clear about that. Food and dietary supplements, FDA has said, right now we're taking the position that CBD does not have a legal basis to be marketed in those products, but it has not said the same thing about cosmetics. It has only said that all cosmetics have to have safe ingredients, and that's the manufacturer's burden. It has not taken enforcement action against cosmetics based on safety concerns. It's only taken enforcement action if cosmetics include what we would describe as prohibited disease or drug claims, which we'll get into in a little bit. So again, from a practical perspective, FDA is really, really focused on those problematic claims. And as we'll discuss, has signaled that they're sort of in this tough situation where, on one hand, other federal agencies and state agencies are liberating the interstate commerce of CBD products, but FDA has some safety concerns. Their primary concern right now is capturing those products that are marketed to treat and cure diseases. Even if you have information to suggest that your CBD product might do this, this is almost a guaranteed way to receive what we would call a warning letter. And once you receive a warning letter from FDA, it's just a matter of time before you will start seeing state level enforcement and follow-on class actions, citing to that warning letter. So if you walk away with anything today, it's, CBD is, from FDA's perspective, a priority, but the biggest priority is to make sure that you are not making those prohibited drug and disease claims. So as I mentioned, FDA has made some positive, I would say, movements to explore different options for overcoming that statutory prohibition. It recognizes that this is a product that's out there in the market. It's not going to, at this point, take a drastic position to seize all products or prohibit it outright unless it finds some compelling safety reason to do so. So a couple of things have happened since that 2018 Farm Bill passed. Last May, FDA held a public meeting to discuss CBD. What they're really interested in, again, safety, cumulative exposure, adverse events, drug interactions, vulnerable populations, and different definition considerations. And then most recently, FDA issued a press release. This was, I think, March 5th. And prior to that, a congressional report on its position on CBD. The report, again, echoes that they're aware that a large number of CBD products are out there in the marketplace, but it still has certain knowledge gaps that it's seeking information from the public. And to that effect, the FDA did reopen a docket to receive any information the public can provide on CBD to learn more about the product and the safety and manufacturing and different, just to fill those knowledge gaps. And I think that is, again, a positive thing. When FDA closes a docket, it can go away forever, and we really don't know what the next steps are. But now, by taking this action to open the docket indefinitely, it signals that there's still active interest and, frankly, resources devoted to this cause at the agency to monitor the comments and review what's coming in from the public. They also, in this press release, which I found to be very interesting, is they seem to be suggesting that as a first step, and this may change in light of COVID, but that they will be maybe issuing an enforcement discretion policy document as opposed to a full rulemaking in the first instance. So, we've seen these enforcement policy documents and enforcement discretion guidance documents come out in various contexts, most recently in light of COVID. So that will be an interesting thing to look out for. I would expect that any enforcement discretion policy that comes out from the agency would have certain requirements around record keeping that may go above and beyond what's required in the regulations as they stand. So, for instance, FDA may say, we're not going to object to the marketing of, a cosmetic product if you maintain certain records, which otherwise are not generally required for cosmetic products. And this is speculation, but this is what I would anticipate just because FDA is in such a data collection mode. They'd want to make sure that manufacturers are doing the same. What I would expect the enforcement policy to also be very, very clear and very tight on the prohibition of drug and disease claims. They may even provide a list of claims that would be, by way of example, appropriate for certain commodities that they are permitting. So we'll have to see. I'm hopeful that within the next 6 months, and again, with with COVID and all of us dealing with that, and especially the agency, it may have slotted down on the priority list, but given the strong indication that something is forthcoming, I would think in the next year we should anticipate that. So with the most recent reopening of the docket for information, I just wanted to pause here and highlight some of the specific information that FDA is requesting. Liver injury, toxicities from active metabolites, impacts on male reproductive systems, co-administration, neurological developments, pet food and pet-producing animals. Again, the transdermal penetration, which FDA is actually independently looking into at the University of Mississippi. Other clinical studies to assess long-term exposure, repeated dose toxicity studies, studies on different routes of administration and the safety profile around that, the effect of CBD on the eye. So these are things to keep in mind as an industry group, whether we can really develop sound data to sort of allay some of these concerns and address these priority questions.
And as Ashley has indicated, as FDA is developing its rules and regulations and deciding how it's going to move forward and opening the docket and looking at the science, which is crucial to making a good decision, they are taking enforcement action. And I think that the enforcement action that the agency has taken is telling in terms of its focus, as Ashley indicated. It's very much focused not on just a broad swath of CBD products, but really looking at what types of claims. And so there's a few statistics that let us know where FDA is really concerned. So they sent out in 2019, late last year, 22 warning letters, and they sent out 15 in November alone. And the focus was really on egregious claims, or claims that really were about CBD's availability and efficacy in terms of treating or curing or addressing disease states. So when you look at the warning letters, FDA was very concerned about and issued them to companies that indicated that CBD could address pain, diabetes, which we know is a challenge in the United States and growing with adult onset and children contracting diabetes, cancer, opioid addiction, which we know is a focus for the agency, and schizophrenia. Products that seem to sort of make no claims or making what we would consider to be sort of more passive claims, like relaxation or addressing stress, were not included in those letters. And here I've included a example of the FDA letters and their focus on these egregious claims. So here we have a FDA warning letter where the CBD is supposedly relieving pain and inflammation, and that it's proven, and that it can lower the incidence of diabetes. And those claims, even if the regulatory status wasn't in question in terms of whether CBD could be included in foods, those types of claims certainly would warrant the FDA's attention. And FTC certainly would be remiss if they didn't have some enforcement action in this area too. As most of us know, FTC has primary jurisdiction over advertising, and they are very interested in what influences consumers to make purchases. And as you might imagine, FTC is in alignment with FDA in terms of claims, in terms of health-related claims in CBD. So they are very interested in claims that talks about reducing diabetes. They're very interested in whether there's good substantiation for cancer claims. And so the agency, FTC, is very interested in whether there's proper substantiation. They expect that CBD, like any other product for that matter, would be backed by competent, reliable scientific evidence if you're making claims for them. They're not limiting their review of the claims to just the product label itself. You know, FTC's jurisdiction is looking at social media. They view likes and other types of consumer review as the company, if you repost it, as the company adopting the claims themselves, even if consumers are making them. So they anticipate for those types of social media posts that you have substantiation for that. And they're also looking at influencers and making sure that if there's a material connection between the influencer and the company be advertised on behalf of, that there's proper disclosures. And these are all things that the FTC is evaluating. And so we have here a letter where FTC is looking at CBD and not questioning necessarily its status under FDA regulations, but very focused on whether the advertiser possesses the type of science that would be necessary to support the claims. And so here we have a letter where the agency is giving the company a chance to come into compliance or to evaluate the claims and revise them to make sure that only those claims on the website or in social media are ones that would have good sound science behind it. The issue with this is that I think, as Ashley indicated, is that there does seem to be a little bit of a gap in the science, and so I think that FDA and FTC, well, FDA is trying to ask the industry to provide it with science, and I think the FTC is questioning whether there should be advertising in connection with these products before the science materializes in the way that they anticipate. Of course, FDA and FTC are not the only adversaries that we have to be worried about. There's private litigants out there. We have consumer protection laws. Most states have what we consider to be mini or baby FDA and FTC laws, which allows the states to take action, but also private litigations to sort of step in the shoes of the state and determine whether the product is either, one, lawfully, like if you have a food product, should it be in the marketplace, or whether there is good substantiation for that. We're aware that there has been some class action litigation in connection with CBD, questioning whether CBD is appropriate as a dietary supplement or really can be included in a food. We are also aware of some class action litigation where there is some question about whether there's an appropriate amount of CBD content. I think at the earlier in the webinar we talked about the forms and content of CBD, and I think that there's some analytical testing that sometimes not everything that's declared on a label is actually found in the product. And so there can be a little bit of a discrepancy between the amount declared on the label and what's actually present. And that's where this litigation that took place in Massachusetts in 2019 is focused on. Then we would, nothing would be complete if there wasn't some Prop 65 question or worry to be raised in connection with Prop 65, which is California Safe Drinking Water and Toxicity Enforcement Act, which was passed in 1986. And as we know, the California routinely updates its list of chemicals known to cause cancer or to cause birth defects or harm to reproductive health. And they expect that if you contain a chemical on the list and it triggers one of those incidences, that you would have a clear and reasonable warning known as a Prop 65 warning. And it's sort of a breeding ground for AG and enforcement and private class action in California alike. And we have had recently an update that THC has been added to the Prop 65 chemical list. And so the question would be begged as to what does this mean for CBD and whether CBD would be subject to Prop 65, because while it's supposed to have little or no THC, some of it has a little, and then unfortunately, there's no safe harbor level currently under Prop 65 for THC. So even if you have a very negligible amount, it can trigger Prop 65 issues. And failure to comply with Prop 65 is very, very expensive. And so this is something, along with whether CBD can be included in foods, this Prop 65 issue is another issue to add to our list as to, what compliance with Prop 65 might look like.
So now, so Prop 65, that is something we'll be aiming to, make sure we're covering in the next few months. As you can see, the compliance date for labeling, should your product need a label, a warning statement rather, is next January. So back to the earlier point of having control over the supply chain and documentation and strong analytical methods to detect that THC level, this is certainly going to come into play in California and everywhere. So, it would be prudent to, at this time, if you are already selling products, to really take a close, hard look at the testing methods you have to detect that THC and consider whether, you may require a warning if you're selling products in California, which I assume, many people are. So we are broadcasting this, of course, from our homes because, unfortunately, we are in the midst of a global pandemic. And what does that do? What impact does it have in the CBD industry, if anything? Well, it's impacting all industries. And, as an immediate reaction, both FDA and FTC are uniquely focused on issuing enforcement actions and warning letters against companies that are making those prohibited disease claims targeting COVID treatments and prevention. So we've already seen a number of CBD products implicated in this initial sweep of warning letters issued in response to the COVID pandemic. Here's an example of one that was sent just recently this April. As you can see, describing CBD as an antiviral agent and reports of antibacterial effects, antiviral effects. Again, if you have information and scientific data to support this, that's great, but, to lawfully market the product as either a food, dietary supplement, or cosmetic, these types of claims are per se prohibited. They cannot be made, and so you will be receiving an enforcement letter if you attempt to make these sort of claims. And we discussed a little earlier also, this concept of follow-on litigation, and we're already seeing class actions, and we're seeing class actions based on the level of CBD in the product, but also these prohibited disease claims are being challenged at the class action level. We've also seen mixed decisions from courts based on whether some courts are actually staying decisions and determinations in anticipation of FDA taking action soon. We've seen that in other contexts before. There are a number of lawsuits brought when healthy became a definition of concern to FDA, and they were working on that. We saw so the same sort of thing is happening at in the litigation circuit, but to different degrees. So I would just say, as a caution there, don't rely on the fact that a case may not move forward because FDA's actions are imminent. We're seeing a mixed bag there. So I wanted to touch on that. Circling back on what we've discussed already today, CBD is growing. It's still growing. In the middle of this pandemic, we're seeing, a lot more products, a lot of marketing. But again, the biggest issue right now is not making those prohibited disease claims and keeping very within the bounds of what FDA expects for food, dietary supplements, and cosmetics. Also really, really important to consider what states are doing. So, as we mentioned in the beginning, there's various state laws, and they are, constantly evolving. So there's a set of regulations governing the hemp production pieces, and then there's also independent state laws around labeling requirements, testing, and then some states that still, to this day, prohibit the distribution of CBD products because under their state laws, CBD is still within the definition of marijuana. So something to consider is that we still have state issues, and those are changing, by the day. And then again, I think, we talked about the information that FDA is seeking, and, considering as companies are developing not only substantiation to support, certain efficacy claims you might want to make, which is very important, but also, this safety information, like can we gather enough information to sort of make FDA's job make it easier for FDA to say absolutely yes, in terms of, how it views certain products that have certain protections around how they're used. So I think at this point, Claudia, if you want to, I know we've received a number of questions from the audience.
Yes, we have. And I will kick off the first one, Ashley. I have a line of products that contain CBD and they don't make any kind of aggressive claims about curing disease. Am I still at risk of FDA and FTC enforcement? And I think that there's two parts to that, Ashley. I think that, one, FDA has still been very clear, even though they have this implied sort of enforcement discretion going on, that they are still struggling and grappling with whether dietary supplements or foods can appropriately contain CBD. So I think that with that sort of outstanding and overhanging, there's always a risk of enforcement action. But I think that if the claims are ones that are not, pain claims or disease claims or high-risk claims, as we've talked about, I think your risk, your ability to sort of fit into this implied enforcement discretion is greater. Ashley, would you agree with that?
I do agree with that. Like you said, I mean, FDA has, even if your claims, FDA and FTC, even if your claims are benign from a disease drug claim perspective, the authority is broad, so you're not eliminating risk completely. I saw another question that was interesting, and to this point, we talked about this statutory exclusion that applies to both food and to dietary supplements. So the question is, can an argument be made that only the isolate as a drug, which is Epidiolex, the drug that was actually approved by FDA, therefore, so long as you have safety information, could broad or full spectrum not be subject to this preclusion as food or dietary supplement. And I do think that that's a very strong argument. And the interesting thing there is that in FDA's that March press release where they said, this is what we're working on and we're thinking about this enforcement discretion policy, they also, for the first time, were asking about, definition differences between specifically broad spectrum, full spectrum, and isolate products. So I really see this as an opening for industry to provide that information, provide those arguments, because, it seems as though FDA's heard some of this and is thinking hard about it. The fact that they even raised those definitions and are seeking more information. So I do think, it's not foolproof and it's still an argument, but FDA seems to be thinking about it more seriously based on that March announcement.
And I think the one thing that I would add to that too, Ashley, is that I think if we could focus on the definitions, it would avoid whether we need to make a larger or more broad legal law change or statutory change. So which would take much longer. So I do applaud the agency for thinking of, a way to do it with the constructs that we have currently.
Yes, I would agree with that.
I have another question. Someone asked about, I understand that CBD is not allowed in food, but is the hemp plant itself allowed in food?
So there, I think it's important to understand what we're talking about in terms of the hemp plant. So certain aspects of the hemp plant are because FDA has opined on GRAS notifications that have been submitted for dehulled hemp seed and certain components of the hemp plant. So it just depends on what aspect of the plant you're using and whether the product complies with those very specific GRAS notifications.
So we have another question, and this is along the lines of COVID. Do we think that FDA's work with CBD is going to be delayed due to COVID? We know for sure we've been helping clients with all manners of PPE and other products that the agency has been issuing almost daily guidances in connection with, that they're very busy trying to make sure that, the country has the equipment it needs to deal with COVID. But I think the centers that are dealing with COVID are not the same ones that are answering the questions about this particular CBD regulation. So I think that we can expect a delay, but I do think that there will be still some progress and that, COVID probably won't overtake some of the agency's progress in that regard. Ashley, do you have any comment on that?
Yeah, I would agree with that. I think, different centers are focused on different things, and it just depends on, what this particular center, which we'd expect, CIPSAN, CEDAR might be working on together. I also think to the extent there is other priorities going on at the agency, which there are, this may be, provide industry with a greater opportunity to really fill that docket and to press FDA and to, put as much convincing evidence in front of them, that they'll have to review. But I don't think, somewhat of a delay that we're seeing in other contexts, but I don't think significantly.
I agree. We're getting a number of questions about transporting CBD and crossing state lines and imports of CBD. Actually, and I don't want the audience to feel like we're not addressing that. It's just that those issues are very complicated and very fact-specific, and we're happy to give some examples of what's happening, but we'll do so outside of this webinar because we definitely would have some questions in order to give a more fulsome answer in that regard.
Yes, I agree. We'll, after this, collect all of your questions and also those in particular response to the transportation issues and provide a summary of where we stand there. I did see another question come in about Proposition 65, and someone had asked, does it matter if it is less than 0.3% with respect to Proposition 65? And the answer is no. As of right now, the chemical THC is listed without any safe harbor. So even if you meet USDA and DEA's requirements to have less than 0.3%, any amount of THC will trigger the Proposition 65 warning requirement.
Yes. So I see one other question, and I think we have time for it, actually. There's one question about third-party or industry self-regulation and whether there's a role in connection to CBD. And I would just start with, I always think that there is a role for third-party industry self-regulation. I think that it the NAD and BBB have proven that those types of self-regulatory forms are very effective and helpful and help keep the heavier hands of, the FTC and the state AGs feeling comfortable that the industry is sort of regulating itself. I think that, and the questions that the agency is asking in terms of that type of where the science is and asking for some more detail on the data, that the regulatory bodies could potentially weigh in on that as well. So I do think that there's a role in that, and that maybe as NAD cases arise, that it'll start to shape what the science really looks like and how to evaluate it, or we'll be able to show that it's been evaluated and vetted, and that will help us get to a faster answer to the FDA and to the FTC.
Yes, I agree with that. I mean, it's been, we've seen these sort of coalitions and self-regulatory structures be a positive thing, particularly as FDA is limited by, certain resources. I think it can only be a positive thing to work together. And to your point on the NAD cases, and that's not something, we'd talked specifically about before, but I'd like to touch on it. Similar to, we're seeing now that there's so many CBD products, as we'd expect, the more products you sell, the more, litigation you will see. So not only class actions, we've seen some cases before NAD, but have not seen any decisions, which is the National Advertising Division, that, refers cases ultimately to the FTC if needed. We have not seen any decisions describing the science around CBD, but I would expect to see some of those cases in the next year, for sure.
Yes. And so one of the last questions I have in front of me actually is about the warning letters that the FDA has issued in connection with CBD. And this is about warning letters in connection with cosmetics. And so I think, Ashley, you correctly described that FDA has not objected to CBD in cosmetics. They've asked some questions about the, whether there's safety around the transdermal use of CBD, but they haven't said that CBD can appear in cosmetic form. I think that the FDA, like any cosmetic, whether it contains CBD or not, if the cosmetic made claims that were beyond what we consider to be cosmetic nomenclature, that the FDA would in fact send a warning letter in that context.
Yeah,
so
that's absolutely right.
Yeah, unlike with dietary supplements, the agency is looking at CBD plus claims. I think that with CBD and cosmetics, that FDA feels relatively comfortable with CBD and cosmetics, and so is really just looking and evaluating it as to whether the claims are appropriately cosmetic in nature.
Yep, I completely agree, and that's really what we've seen. Some of the pain relief claims are hot button issues for FDA and cosmetics. So, to the extent you're considering marketing a cosmetic, I would encourage you to review FDA's warning letters to those cosmetic companies, and try to make sure that the claims are consistent with FDA's expectations.
Yes. So I think that those are all the questions that we can answer here. Again, the transportation claims are ones that we will collect at the end and do a summary. But I think those are all the questions that we have, Ashley, unless you see a couple more that you would like to answer.
No, I think we've answered a good amount, and we don't want to keep you guys too much longer for your afternoon. But really appreciate you tuning in with us. If you have any questions, any follow-up questions, please feel free to reach out.
Especially about Prop 65, I think that is can be an interesting conundrum for the CBD industry. Thank you for joining us today, and we will be our slides will be available, and we will summarize some of the questions we couldn't get to and get back to the individuals with those questions.
Thanks, everyone. Have a great